And further, in as much as the DIOS has refused to comply, has refused to pass any final order in view of certain review application having been recall application having been filed by the Committee of Management in writ petition number of certain 1W application 5 having been 2007 recall application having been filed by the Committee of Management. At present, petition number of certified 1W application 5 having been 2007 by this call with respect to joining having been filed by the Committee of Management on the post. At present, petition number of certified 1W application that matter is pending with the DIOS call with respect to as to the reason filed by the Committee of Management disclosed in the communication made by the certified 1W application that matter is pending with the DIOS call with respect to as to the reason filed by the Committee of Management disclosed in the communication dated 15/1/2014 issued by the DIOS, the same as to the reason unsustainable. Mere pendency of a recall application, neither issued by the DIOS has the effect of restoring unsustainable. Mere pendency proceedings of a recall application by the neither final order passed there has the effect of restoring of which recall may be sought. Not any legal impediment, neither final order passed there has the effect of restoring consider which recall may be sought. Not any legal impediment, neither final order passed there has the effect of consider which recall may be sought. Clear direction. Not any legal impediment, accordingly the final order passed there has the direction on this one number. Clear direction. DIOS on this one number to give full effect. DIOS on this one number to give full effect. DIOS ये तो आपने नहीं बताया अभी तक रिकॉल लगाओ give full effect. Stay order नहीं ये तो आपने नहीं बताया अभी तक रिकॉल लगाओ give full effect. Stay order नहीं ये तो आपने नहीं बताया रिकॉल लगाओ offered not new legal impediment, not legal offered in clear action score rating 4932 46728 in clear action score rating 4932 also the fact that such recall application has been allowed but the interim order but no interim order has been scored but the interim order has not been revived. Also the fact that such recall application has been allowed also with the interim order but no interim order offered any but the interim order has not been revived. Also not give the fact that the non allowed also with the interim order offered any but the interim order has not been revived. Also not give the fact that the non-allowed substantial allowed also the order offered but the also not give the fact that the non-allowed substantial pass appropriate result order unless the order of the respondent establish the existence of any interim order pass appropriate result order unless any other order of the respondent as may prevent establish the DIOS of the order from making such result order unless any other order of the respondent as may prevent establish the DIOS of the order decide to the DIOS of the decide to the DIOS of decide to What is this? Huh? Just wait, let me go through the last one. Huh? Just wait, let me go through the last one. Huh? Just wait, let me go through the last one. Huh? Who appears for response number 4? Just wait, let me go through the last one. आप आ गए? Who all have filed counter and who all want to file counter? Who appears for response number 4? Counter आपने सबने फाइल कर दिया? Just wait, let me go through the last one. आप आ गए? Who all have filed counter and who all want to file counter? Who appears for response number 4? Counter आपने सबने फाइल कर दिया? Just wait, let me go through the last one. आप आ गए? Who all have your counter and who all want to file counter? Who appears for response number 4? Counter आपने सबने फाइल कर दिया? You have filed your counter. अच्छा, you have filed. Yes, file counter. क्या? You have filed your counter. दो ही पार्टीज हैं कि 4 पार्टी? अच्छा, you have dispute is between Kumpari Chandrama. क्या? Ramashish is not a party in the petition filed by Kumpari Chandrama. You have dispute is between Kumpari Chandrama. Ramashish is not a party in the petition filed by Ramashish has sought a relief against Kumari Chandrama. Chandrama. Ramashish is not a party in the petition filed by Ramashish has sought a relief against Kumari Chandrama. Chandrama. 6th को हमने क्या हमें पैसे थोड़ी Ramashish has sought a relief against Kumari Chandrama. Chandrama. 6th को हमने क्या हमें पैसे थोड़ी Ramashish has sought a relief against Kumari Chandrama. 6th को हमने क्या हमें पैसे थोड़ी इसमें डेट नहीं लगी? अच्छा, रीडिंग केस में डेट नहीं लगी? लिस्टिंग केस में डेट नहीं लगी? 2213 क्या लिस्टिंग केस में डेट नहीं लगी? 565 वेटेड क्लेमेशन नंबर 565 वेटेड क्लेमेशन नंबर 565 करते हैं वेटेड क्लेमेशन नंबर नाउ अगर स्पाइल हम लगाइए वेटेड क्लेमेशन नंबर नाउ अगर स्पाइल हम लगाइए डॉक्टर ने लगा तो केस बाय केदारनाथ इंश्योरेंस फाइल appearance on behalf of respond number case for केदारनाथ इंश्योरेंस फाइल appearance on behalf of respond number case for केदारनाथ इंश्योरेंस फाइल आपसे कोई मतलब नहीं आपसे कोई मतलब नहीं आपसे कोई मतलब नहीं रह पाते board and the state government and board say board and the state government board and the state board say board and the state board and the state board आपको कुछ नहीं करना तो काउंटर आ गए अरे भाई पहले वाले में बताइए 18549 अच्छा आप परिहार फाइल काउंटर शॉर्ट काउंटर एफिडेविट You don't propose to file a long counter, तो काउंटर आ गए अरे भाई पहले वाले में बताइए 18549 आप परिहार फाइल काउंटर शॉर्ट काउंटर एफिडेविट and the candidates having been selected you don't propose to file a long counter, काउंटर आ गए अरे भाई पहले वाले में बताइए जो सिलेक्शन हो चुके जहाँ हो गए अब एग्जिस्टिंग सर्वाइविंग वैकेंसी के अगेंस्ट जाएंगे तो आप क्यों 6 करा अरे भाई पहले वाले में बताइए जो सिलेक्शन रिवैल्यूएशन पे आप जहाँ हो गए आपको कहाँ करेंगे सर्वाइविंग वैकेंसी के अगेंस्ट जाएंगे तो आप क्यों 6 करा अरे भाई पहले वाले जो सिलेक्शन रिवैल्यूएशन पे कराइएगा जहाँ हो गए उसका स्टेट आपके ऑफिस जो कर रहे हैं सर्वाइविंग वैकेंसी कोई ज्यादा ऑप्शन छोड़ नहीं रहे हैं आज तक ऑर्डर इन ऑल दोस केसेस वेटलिस्ट में कितने हैं जो आपने डबल रिक्विजिशन किया सब सुपर न्यूमेरिक जो योर ऑफिसर्स हैं वो कराइएगा जहाँ हो गए उसका स्टेट आपके ऑफिस जो कर रहे हैं सर्वाइविंग कोई ज्यादा हो गया 2 रिक्विजिशन हो गया कभी इन्होंने एग्जाम आज तक ऑर्डर तो यहाँ दूसरी वेरिएशन है जो आपने डबल रिवैल्यूएशन हो गया सब क्या पर कोई ऑब्जेक्शन नहीं है आपका योर ऑफिसर है वो कराइएगा जहाँ हो गए उसका स्टेट आपके ऑफिस जो कर रहे हैं सर्वाइविंग कोई ज्यादा हो गया 2 रिक्विजिशन हो गया कभी इन्होंने एग्जाम आज तक ऑर्डर यहाँ दूसरी वेरिएशन है जो आपने डबल रिवैल्यूएशन मगर वो ज्वाइन कर चुके हैं तो इसलिए वो प्रोटेक्टेड रहेंगे स्टेट आपके ऑफिस जो कर रहे हैं सर्वाइविंग कोई ज्यादा हो गया 2 रिक्विजिशन हो गया कभी इन्होंने एग्जाम आज तक ऑर्डर यहाँ दूसरी वेरिएशन है डबल रिवैल्यूएशन मगर वो ज्वाइन मुझे कहा कि ठीक है जॉब कर रहे हैं काफी समस्या तो इसको हम लोग कर देते हैं आगे सुपर करते हैं आगे बढ़ने को ये तो आगे के लिए उम्मीद रहती है मगर फिर आगे आप लोग जैसे ही पैनल आया है यहां से रिवॉल्यूशन पैनल हुआ तो कोशिश की होगी ठीक है शॉर्ट काउंटर एफिडेविट हैज बीन फाइल्ड बाय श्री परिहार full stop rejoinder if any may be filed within 1 week who else wants to file a counter in this 18549 state का counter 413 कर दिया नहीं connected कर दिया इसमें learning standing additional chief standing counsel prays and is granted 2 weeks to file counter if any full stop rejoinder may be filed on the next date put up on 6th along with writ A 2565 of 22 just wait call out होने दीजिए connected matter this Imam Singh other secretary Shahi work drafting इसमें क्या हुआ आप कह रहे हैं कि आप तो एंटाइटल्ड है अंडर because I have already submitted my body and on the basis of the law decided by this honorable court on the basis of the judgment rendered by honorable Supreme Court in the case of yes I am very much entitled to contribute आप क्या है इसमें 5 और 7 कुमारी चंद्रमा और राजकुमार संध्या सिंह तो इस लॉ को आप अपोज कर रहे हैं क्या आप किससे आए हैं रिवैल्यूएशन तो ये जिस पे रिलाई कर रहे हैं उसका क्या करेंगे जिस लॉ पे रिलाई कर रहे हैं दैट बिकॉज दे इसके लिए डेट बता दीजिए रिजल्ट कब डिक्लेयर हुआ अपॉइंटमेंट लेटर कब इशू हुआ इन्होंने ज्वाइन कब किया और रिवैल्यूएशन का ऑर्डर कब हुआ और रिवैल्यूएशन का रिजल्ट आया पैरा नहीं आप बता दीजिए डेट नंबर 1 ज्वाइन ऑन 1/12 पहले रिजल्ट कब आया rejoinder you have filed I have to file you want to file you don't want to बोलिए तो आप किसके कितने काउंटर हैं इसमें how many counters have you received Mr. Singh 5 काउंटर आपके लिए फाइनल लेटर आया 29/10/2021 ठीक allotment लेटर इशू आया 29/10/2021 जस्ट 1 मिनट इसमें डेट लगी हुई अच्छा ये उसके साथ आएगा ठीक ठीक देन नॉट टुडे बताइए हाँ इसी में तो ऑर्डर है 2565 यस सो हाउ मेनी काउंटर्स हैव यू रिसीव्ड 5 काउंटर्स है ऑलराइट counters are on record. Stop Lawrence counsel for the petitioner pays and is granted a week 2 weeks time to file rejoinders. File rejoinders on or before the next on the date fixed कर. So pays and is granted time to file rejoinder affidavit on the next day. Put up on 6th. तो इसमें तो ऑलरेडी ऑर्डर है, इसमें कुछ नहीं करेंगे, इसमें कोई ऑर्डर करिए ही मत, हटा दीजिए, पूरा ऑर्डर कर दीजिए, वो तो है। यस अब पार्टनर बेटर और 3 बजे शुरू करिए पार्टनर, 3 बजे शुरू करिए जब तक करना है। तो मेंशन 1 लेंगे 4 बजे। मोहम्मद फारूक अंसारी का खान सिद्दत सिंह You said there's impediment.
Yes, there is impediment application. We will need Union of India and the University grant.
The impediment application. Fresh state पे ये काउंटर नहीं आया। है नहीं रिकॉर्ड पे, है क्या है? काउंटर है रिजॉइंडर नहीं है। देख बताइए ट्रीटमेंट एप्लीकेशन 3 of 21 करिए। Stop being necessary parties. Let Union of India and University Grant Commission be impeded as party respondent numbers 5 and 6 to the written petition. Full stop. Amendment impediment application is allowed. Full stop. Let impediment be carried out within a period of 1 week. Full stop. Issue notice to the newly within 1 week, within 5 days. Full stop. Issue notice to serve. Issue notice to newly added respondents fixing 1st March. Full stop. Steps within 1 week. Steps may be taken on or before 23rd December 2020. Full stop. All respondents 6 weeks, 2 weeks first. आप कर लीजिए जो किनके काउंसिल हैं। अच्छा ठीक है, स्टेप्स वो हटा दीजिए, इशू नोटिस कर दीजिएगा। In view of the fact that the newly added respondents are represented through panel counsel, full stop. Let notice be served on the newly added respondents through their panel counsel. Full stop. They may file counter affidavit. किसको करेंगे सर? UGC के कौन है? Let notice be served on the ASGI and Shri रिजवान। आप हैं? नहीं, इनका नाम शो करवा देना। मिस्टर रिजवान अहमद, मिस्टर रिजवान अली अख्तर within next 3 days. इतना कर लीजिए। Those responsible subject to learned counsel for the petitioner communicating this order to the counsel for newly added respondents. They are granted 6 weeks, 2 weeks. List on 1st March, showing the name of showing the ASGI and Shri Rizwan Ali Akhtar as counsel for the respondent, also as counsel for the respondent. कितना करेंगे? वो आएगा अर्ली डेट, सब चीज शॉर्ट में थोड़ी जाएगी। फिर आप कहते हैं आप ले जाते हो, काउंटर भी आ जाएगा। ऊपर फिर लिखिए रिजॉइंडर एफिडेविट फाइल। काउंटर है आपका रिकॉर्ड? रिजॉइंडर एफिडेविट टू द काउंटर फाइल बाय यूनिवर्सिटी टेकन ऑन। नंबर 8 BSN 9 कुमार Decide. What is the matter?
Matter of creating in fact I was a teacher in the college established by the same that is exempted as the parent of service 38. Thereafter I have been selected as a principal in the aided institution. I am saying that my services will be created for other benefits.
The auxiliary benefits, they have to be included. Why have they not included? What reason do they give?
They have that page there.
55 पे
Page 54, 55.
प्रकरण में वित्तीय परामर्श वित्त नियंत्रण से स्पष्ट किया गया कि शासन आदेश 28/12/1 के अनुसार निगम उपक्रम कर्मचारियों की सेवा पेंशन हेतु आंकड़ित नहीं की जा सकती है, क्योंकि ओबरा इंटर कॉलेज ओबरा सोनभद्र वेतन वितरण अधिनियम से आच्छादित है। अतः उप विद्यालय को भविष्य
Recognized intermediate से payment of salary total 30 में because it is a government organization of the state of UP.
What?
ये under the electricity board act, the government is making payment of the salary to the teachers. Consequently, on the separate clause, payment was given by the government, but it is separate. Therefore, under section 30 they were excluded. हमने लगा रहा है सारे government orders. मेरा निवेदन है अगर ये पढ़ ली हो अभी तुरंत में पास कर, नहीं तो काफ टेन में लगा के कहीं हफ्ते पढ़ दे वो आई एम नॉट गेटिंग सैलरी आई गॉट रिटायर्ड पढ़ लिया। हां 2001 गवर्नमेंट ऑर्डर है।
No, at present let us see what is the rule. When will what service is to be included? In the first place, service rendered in a aided non-government.
Service rendered in the organization of the state. Whether we are getting a better than salary benefits, these services will be counted.
Under which provision?
Yes.
Under government order.
Under government order.
There is no rule. वही तो आएगा ना, वहां से देख लीजिए कब करेंगे, नेक्स्ट वीक।
नेक्स्ट वीक में टॉप 10 कर देंगे
ऑलरेडी प्रायर सर अर्लियर सर्विस जो रेंडर्ड है वो इंक्लूड होनी कि नहीं, बिकॉज
और वो गवर्नमेंट ऑर्डर दिसंबर 2001 में स्पेसिफिक बताया कि इसको इसकी सर्विस जोड़ी थी।
दिखाइए। हाँ यस
बॉटम से सेकंड लाइन तो देखिए इससे स्पष्ट है कि शासकीय व्यवस्था स्वायत्त शासी निकाय ऑटोनॉमस बॉडी
ऊपर लिखित से स्पष्ट है शासकीय व्यवस्था स्वायत्त शासी निकाय। हाँ ठीक है, ऑटोनॉमस बॉडी यहाँ जहाँ पेंशन व्यवस्था लागू है में लागू की गई,
परंतु उस आदेश में प्रतिकर स्थानों पर स्वायत्त शासी निकाय के स्थान पर निगम ऑब्लिक उपक्रम शब्द का प्रयोग किया गया, जबकि भारत सरकार ने इसका प्रयोग किया है कि उपक्रम ऑब्लिक निगम के कर्मचारियों की सेवा पेंशन हेतु आगे
भारत सरकार ने।
इस संदर्भ में मुझे ये कहने का निर्देश हुआ है कि शासनादेश 10/7/1998 की व्यवस्था स्वायत्त शासी निकाय में लागू की जानी चाहिए। उपक्रम ऑब्लिक निगम अगर ये
ठीक है, उपक्रम निगम में नहीं है, फिर आगे क्या कहा? स्वायत्त ये आपने गवर्नमेंट ऑर्डर है, गवर्नमेंट ऑर्डर इज नॉट द प्राइमरी लॉ, राइट? Largely it remains an executive instructions unless there is no law applicable.
तो पढ़ने में कवर हो जाएगा मेरा।
हाँ वही पढ़ाने
तो जैसे निकाय का आपसे ऐसे निकाय से जिनका भी पोषण कहा हुआ 50% से अधिक व्यय की पूर्ति राज्य सरकार के अनुदान से होती है। हमारे पूरी तरह से स्टेट गवर्नमेंट जिससे इलेक्ट्रिसिटी बोर्ड के साथ हुआ था सरकार से पेमेंट हो रहा है। इलेक्ट्रिसिटी बोर्ड को आप ये दिखा दें कि एक्ट में वो एक्ट से दिखा दें कि
आप प्राइमरीली हमको पहले रूल से दिखाना शुरू करिए, जब रूल में डाउट होगा तो गवर्नमेंट ऑर्डर देखेंगे, अगर रूल होता ही नहीं 309 का भी कुछ ना हो तो फिर गवर्नमेंट ऑर्डर पे देख लेंगे। पर जब आपके यहाँ स्टैट्यूटरी रूल बना हुआ है तो आप उससे इनका क्लेम या तो ये आप इसमें इंक्लूड कराएंगे या आप इसको एक्सक्लूड कराएंगे, बट वी कांट पास एन ऑर्डर विदाउट लुकिंग इनटू द रूल। रूल में क्या इंक्लूड होगा दिखाइएगा। Petitioner claims entitlement to inclusion. Petitioner claims entitlement to inclusion of service rendered at school established by at Obra. Obra school established by UP Electricity Board. For the purpose of computation of pension payable. Full stop. And council may examine the matter further in the context of statutory rules. Full stop. Put up on 21st. तो ऐसे ही ऊपर आएगा 20 का टॉप 10 ऑलरेडी। नहीं तो we hope to conclude that matter, but ठीक है। ठीक है काउंटर जस्ट 1 मिनट।
And I intend to conclude my submission today. Because it appears that probably will be having this test in December only.
Right?
As per our general
You consult parents.
it should be in the division that they are.
We'll be consulting parents then. We don't know. But in any case, what you start on one side of the session, you should end it on that side.
That is our question.
So, but you take your time. The points you have to make clear. That's not an issue. Process of recruitment was in accordance. Yes, please proceed.
Hello. The first was the conduct of the examination. Conduct of the examination. There are allegations with regard to the conduct of the examination. These propositions and submissions have been made on the basis of the allegations and objections which have been made in the impugned order. So one of the objections is that there was a hurried examination held. The answer key was not uploaded prior to declaring the final.
It was uploaded much later.
Much later. Lots of our submission with regard to that is that as a candidate, it is not our responsibility as to when the answer key would be uploaded.
Just one. Give me a minute. Yesterday, you said the two opinions that were available to them have been read selectively. Whatever part they like, they have read it, and on that they have extended their reasoning.
That part also I will.
1. 2. You say conclusions are only in the opinions are only doubts. They are not conclusive, definite opinions as to fact.
Lord, that is.
Then you say Jal Nigam has always followed the same procedure. They never uploaded the answer. And impugned order refers to CIT report, but that was never filed. And then you say you will rely on FSL report. Because you are laying a ground of challenge. With that you may cover what they are going to offer by way of defense. But why should you address their defense first? Whatever they will say, they will say.
I am addressing the submission on the basis of which the impugned order is done.
You are assailing the impugned order.
Yes.
So for that 5 points you refer
Those
to.
points I have elaborated.
Those we have elaborated. Now
Yes.
let's go by that.
Right.
First you say that so far as the first part is concerned, I think in the reading of the order, then you've already covered that the opinions have never expressed any definite opinion as to facts.
Right.
They have just left it at doubts. They say because these things were not provided, therefore we cannot say
Right.
whether this happened or not. Right?
Yes.
Now,
But
so far
there
as
is one more added ground to that. The Lordship is addressing that. Lordship idea page number 218. That was the affidavit filed by the Judge Government in the earlier proceedings. That is 145.2.
218.
218.
That is an affidavit filed in Amrish Kumar.
My lord, 145.2 of 2017. Wherein all the orders. In this, these reports came for the first time before any court of law with regard to the junior team. Now, Lordship may kindly see first is the report of the IIT Kanpur. That is on page number 223. My lord, as your lordship has yesterday observed that it doesn't matter the report JEE की RCC की, but there's one thing that we appreciate that the specific findings, for example, कि मेरा डेटा 1 जनवरी 2017 को मॉडिफाई हुआ. This will be different for RGC and different for.
If there is,
and therefore I say
to that extent the report is not relevant for junior engineers. That finding is specific only to one exam out of 3. That is, see, there are general observations which may apply to all. There are specific observations that will apply to particular. Right?
Kindly have the report. May I just say?
Yes, 223.
223. Just dates are with regard to RDC, there is no dispute to that. Upon examining the contents of the file presented by Mrs. Abdul Limited, it appears that the earliest modification date of any file in CD is much after September 2016. In the computer page, there's the
earliest modification date.
Yes, my lord. That is the date of examination itself. Typing test was conducted on 7th of September 2016. Lord.
They are considering. So just 1 minute. Online examination was conducted on 5th, 6th, 7th. August 5th, 6th, 7th, 16 and typing. Now which is this test? This is only RGC.
This is routine grade class. In that there is a typing.
So result was, this report then is entirely for RGC.
RGC. That is what our submission was.
Okay.
See, all the findings.
So they have not even seen. This matter was not even referred to them. That's what you said.
Yes, my lord. And that is also fortified from the fact that even when I made this specific pleading in the writ petition, and the counter affidavit, yet again the same report has been filed, which is, my lord.
What is the date of this report? Report of.
This is report dated. My lord,
3/5. 3/5 signature.
2019 is the endorsement, my lord.
Report of Dr. Satyadev.
ये तो अधिशासी अभियंता का वो है,
ठीक है, वो नहीं है. So this is
data on the covering page 220.
okay.
3/1/2019.
Only with respect to RGC.
Now, the facts as it reveals, because they are not mentioned anywhere.
No, they are clearly mentioned. First, top of the page. Top of page 223. A brief chronology. So they are only referring to RGC exam.
Yes. It says about the audit trail, it says about the checksum, and those two perhaps would be also true for us. But why it is true, can you appreciate? The data which was sent to IIT and triple IIT was the CD compact list which was provided by LabTech with regard to the results. Okay, this is the merit list, this is the cutoff, and these are the marks which have been obtained by the candidate.
वो तो ठीक है. So 16 में हुआ दूसरी September 16.
September 16. In the computer-based test, the response of in the computer-based test, the response of the candidate is uploaded in the main server. In the present case, the cloud server. Immediately after the completion of the exam, each candidate's response is secured so that interpolation or manipulation is not possible afterwards. In the present case, the submitted file was modified after September 2016, which raises a strong doubt and it cannot be ruled out that the response sheet of candidates were not manipulated during this period. Under the present circumstances, it is not possible to independently confirm that response sheets of candidates in the CD made available are the same as the response made by the candidates on the date of examination. There is no file in the CD provided by Mr. Septek with the last modification date equal to the date of the examination. Since I have been informed that the primary data on the cloud server is no longer available, it is difficult for me to corroborate that the data provided on the CD is an exact copy of the data available immediately after the completion of the exam. Now, Lordship may just take a note of this assumption or this information which has been given. Since I have been informed that primary data on the cloud server is no longer available. In fact, in the SIT report, in one of the questionnaires, the specific answer is it was downloaded.
Yes, you said that. But these are only doubts being raised because you have been informed.
That is an added
But again, this is not with respect to all examinations, this is only RGC.
No audit trail containing the individual mouse clicks and timestamps of choices have been made by the student as been provided in the CD. Such an audit trail will make it easier to corroborate that the answers given by the students in examination is the same as the answer sheet that was graded on later. Such an audit trail is helpful to settle the discrepancies and challenges that the exam candidates may later face. Since Methods Aptech Limited has not provided such an audit trail, it is not possible for me to corroborate and confirm that there are no discrepancies between the students' actual response and those which were used for grading. Moreover, I am informed that the standard procedures followed in public examinations like JEE, Mains, JEE Advanced and GATE were not followed. It is a customary practice in these exams to publish the answer key to the exam, invite any objection and rebuttal for the candidate, consolidate these responses, and subsequently freeze the answer key. Grading the answer sheet is done only after such an opportunity has been provided to the candidate. This common practice has not been followed in the present case, which raises doubt. Which raises doubt as well as apprehension that the response sheet of individual candidates might have been compromised. The errors in answer key of this particular examination may have been reduced or eliminated altogether. Had such an opportunity been given before the publication of the results of the computer field test. Considering the lack of primary data with Aptech Limited, it is not possible to independently confirm the authenticity of the provided data on the CD, and hence the segregation of tainted and untainted candidates is not possible. Now, Lordship may kindly appreciate one that it only shows the apprehension and the doubt, and secondly, what is the comparison being made? It is a comparison of the exams being held by JEE Mains and JEE Advanced. There are several exams. I have made a specific reading in one of the paragraphs. I will just refer that paragraph. Where I have stated.
Is there any letter that the government or Jal Nigam are pretending to be experts? What was the context on which opinion was sought?
On which opinion was
there is a letter. What is the context of the opinion?
This particular, but that letter is not.
That is not there in the pit record.
They have not filed it, but it is on page 2. Triple 2.
So that is the triple 2 of what?
It says with reference to your letter C dated.
So where is this has not been filed?
This has not been filed by
I have filed it in the 4531.
4531.
It's a very influential letter. The works have been
We have not seen it as video.
My lord, this one secretary is a letter written to triple IT Allahabad.
Whatever, they would have written similar letters.
Triple IT report has not passed the letter. So there, the gentleman has very fairly noted the context in which that opinion has been given. And that is the opinion with regard to the nuclear engineers, there is no doubt about it. That opinion is on page number 225. But probably similar letter must have been written to IIT. With reference to the letter number so and so dated 27/11/2018.
Just 1 minute. No, I've got it. So it is 27/11.
Both are same people.
2019-18, yeah.
18 both.
Probably same. Undersigned.
Marked to the Director, Indian Institute of Information Technology, Allahabad, the undersigned was identified to evaluate the matter captioned in the subject above. Toward this, following a discussion over telephone with you, the undersigned visited your office at Lucknow and spoke with concerned officials and reviewed the document and the data available there between 13-14 December 2018. This report is a composite evaluation of both the junior engineer and routine grade clerk recruitment process. Both these recruitment types entail 3 stages. The key observations are enumerated below. The answer key to the computer-based test of both the recruitment rights were made available by the service provider to the general public applicant via the UPJN website after the appointment letters were issued to the successful candidate of the respective course. This grave error on the part of the service provider denied any applicant from sharing their critical comments about the correctness of the questions in a timely manner before declaration of the results, and thus denied a fair chance during the overall recruitment process. Following reports from the candidates and subsequent evaluation by subject experts, 7 questions were found to be incorrect in RDC and 18 questions were found to be incorrect in JEE examination. Thus, objection 18 out of 400 appear out. Thus, objections raised by the candidates in connection with the validity of the questions in the computer-based test hold merit. Office note highlights that 2 candidates' appointment letters issued for the post of junior engineers were cancelled due to discrepancy in the applicant gender data, which led to selection of these 2 candidates against post results for women candidates. These 2 candidates were with the enrollment number so and so. There is no record available of any checksum.
2 were invalid.
2 were invalid. That is.
वो तो cancel हो गया
There is no record available of any checksum of the candidate's response being computed immediately after the closure of the exam session for each candidate. Neither was any checksum computed provided for the response database, which would inevitably have been created as the candidate's response were recorded. Nor were these checksums of the candidate response overall response database, if computed, shared by the service provider with the office of UPJN. This is applicable to the typing proficiency test of RDC recruitment test as well as the CBT for both posts. Concurrent to the terms and conditions of the contract between UPJN and the service provider was responsible for generating the question data bank from the online computer-based test. This is enumerated by item number 7 on page 3 of the contract document for both the recruitment processes. The service provider was tasked with biometric registration of the candidates by item A of the examination stage activities in the contract document and maintenance of attendance record sheet with photo, thumb impression and signature with each examination at each test center. There is no record available with the service provider that it provided the information listed in the contract document item B under the examination stage activity. There is no record that all the data pertaining to computer-based typing test and computer-based material choice test is still available in the original server, cloud server. The service provider has submitted their applicant and examination data on multiple compact disks to UPJN. None of the files of these series have checksum incorporated provided with them. All the candidates' response files of GAIN CBT presented in SQL seems to have been modified on 25th February 2015, which is almost 2 months after the announcement letters of successful candidates were sent out. Now, here is the data which you are also like to take note of. On 14th of February 2017, even as per the admitted case, the data was uploaded on the website. All the answer sheets of the candidates, answer keys, and thereafter response sheets were uploaded. It was available till the time of filing of this petition, actually, because even I had seen at that time. The answer sheets of the candidate was also uploaded. So if it was uploaded on 14th of February, what was the occasion to modify it on 24th of February 2017, 10 days thereafter when it was already in the public domain? Probably what has happened is, even the data were being copied to the compact disk, then the file's date comes on the date of copy. If I'm copying something, then the date of modification comes on the date of copy.
We don't know, but it were uploaded
On 14th of February 2017. Then what was the occasion to modify it on 24th?
and any modification, you may say the modification made thereafter is of no consequence because that is there.
All the candidates' response files, all the candidates' response files for the RGC CPC presented in HTML format seem to have been modified on 8th March, which is just over 3 months after. This is also after that particular day. On that day, all the 3 exams, answer sheets and everything was uploaded. All the HTML candidate response files that were provided on the CD contain structured links to images of questions that were presented to the candidate along with the response of the candidate to each question. However, each and every question shown in these files is also followed by the correct answer and its explanation. Now, Lordship, phase 2 to 7 is very relevant. Prior to any conclusion, it has been a bit under the line. Prior to any conclusions being drawn from these observations, it is necessary to establish the scope and context of this evaluation. While the scope is being limited to technical aspects of the testing process and the rigors with which both the recruitment tests were conducted, the context is established by way of the following two assertions. UPJN is of the opinion that testing process for the post of assistant engineer conducted by the same service provider was compromised as mentioned in letter dated so and so, which leads to the tacit implication that UPJN believes that overall testing process of the other two posts has also been compromised. You are seeking an opinion and you are telling that gentleman, we have a doubt it has been compromised. Referring to the letter, Honorable High Court has instructed UPJN to identify tainted and non-tainted candidates. This implies that Honorable Court has accepted the assertion of UPJN that overall recruitment process could have been compromised. This is the order passed by the division bench of this court, which was subsequently affirmed, wherein there was an observation that you may segregate the tainted and untainted, but all other processes were decided in favor of the petition. Even the 4 copying module, the 4 of the candidates have copied the same, a finding was returned that they were sitting in different centers in different districts. Conclusion. Considering the generation of question bank is a human task, there is always room for errors in the question. This is especially true in cases where the testing question bank is generated by an external agency, which then possibly outsources this task to individuals who may not be subject matter experts. Therefore, for observation 1 and 2, the standard operating procedure of posting the answer of the test for perusal of the candidates to enable them to share their concerns and observations about the correctness of questions before even preparing any list of qualified candidates were violated in both the exams. This problem was further accelerated by proceeding with the recruitment process and issuing appointment letters. This led to several candidates being denied a fair opportunity of overall selection process. Observation 3 highlights a particular egregious oversight in the testing process. Under the fair assumption that the 2 candidates made a genuine error while submitting their application form online, both these candidates would have been, as per observation 6 and 7, subject to verification and scrutiny during their CVT and then subsequent interview stages. It is inconceivable that a mismatch in the gender data was not identifiable in both these stages for both these candidates. Therefore, it definitely casts doubt on the diligence exhibited by the service provider and the sanctity of the candidate's identity. testing centers and by the reasonable and logical extension of the testing centers. Ensuring due provenance of applicant testing data is vital. In other words, in the event that an audit is required to verify whether applicant test record is untampered, there must exist a robust audit mechanism, audit trail mechanism. To perform this assessment, the original response data of the candidate captured immediately at the closure of the examination window, along with relevant checksum information is required. This reference information, as per observation 4 above, was neither recorded by the service provider nor communicated to UPJN. Therefore, the sanctity of the testing data cannot be implicitly assumed. In the absence of information, as per observation 4, and by noting observation 9 to 11, the authenticity of the data as and in the form provided cannot be accepted or verified. It has not been held to be corrupt data or otherwise manipulated. What has been held as it cannot be accepted or verified. They do not verify it, this data has been manipulated. And that is the specific conclusion which has been written in the review. The sanctity of both the equipment process seems vitiated in view of the observations made above. All the above observations are based on implicit condition that all the documents and data shared with the undersigned have a verified provenance and response provided by the personnel made available for interaction with the undersigned on 13th and 14th at the UP Jalgam head office in Lucknow are true. Additionally, this report uses two technical terms which are being explained below for your convenience. Checksum, a small block of digital data generated by the checksum algorithm, and thereafter SQL. I hope this report addresses the request raised by you in your letter dated 27/11/2018 to your satisfaction. Now, should we just have a look at the report also. At the letter dated 27/11/2018. This is in writ petition number 45315. Sujit Gupta, page number 163.
Page
163.
yes.
Kindly refer to our earlier letter number dated 31st August 2018, copy below. In the above matter, we are grateful for the kind assistance rendered by IIT in the matter. Expert opinion of Dr. Ashutosh Mishra in the matter was submitted before Honorable Supreme Court by the closing of the matter. Honorable Court has given Jalgam liberty to initiate action in all the computer-based examinations conducted by UP Jalgam in 2016 besides assistant engineer examination. There were two other examinations for recruitment of junior engineers at UP Club conducted by the ATEC, which also had conducted tests for assistant engineers. And the same organization also has conducted the other two examinations. We would take this opportunity to request you to assist us to assess the sanctity of the examinations conducted by methods ATEC for JE and RTC. The process of examination has been found to be compromised by ATEC. In the case of assistant engineers, your expert opinion would go a long way to ensure justice in all the candidates who appeared in the examination. Lordship, on the day when this letter was written, there was actually no report even with regard to the assistant engineer. The earlier order was set aside by the division bench and thereafter it was confirmed by the Honorable Supreme Court. These two reports were already and it was placed before the Honorable Supreme Court and the Honorable Supreme Court said we are on the basis of investigation you take action. No action was taken till 27th of November 2018. So on what pretext did Jalgam even write this that assistant engineers was found to be compromised? That order was actually set aside, and it was set aside in all the stages reviews thereafter again before the Supreme. So this is only for the purposes of drawing the lordship to the modified action. Before I place the SIT, just 2 or 3 formal points which I will address to your lordship. One is the process of recruitment was in accordance with the advertisement. Below the advertisement, your lordship will find that is annexure number
Mr. Mishra,
2.
now since you are in the submission part, it will help if you will structure it. First, you are saying the one you have addressed is this is saying that one opinion is not definite.
To the junior engineer's account.
Right.
And the other opinion is contextual and it is not conclusive. In fact, both opinions are not conclusive. Even for if that particular opinion of IIT is to be read as an opinion for junior engineer, for let's assume for argument's sake that the dates have been mentioned and the J date was not mentioned. And even the junior engineers were referred to the same gentleman by the common letter. And it appears that in IIT also common letter was sent. And the report is
Get that exact thing that you are submitting is the opinions are conjectural on the material, so far as this conclusion is wrong, they are only expressing doubts, leaving it at that. But if you read that these are definite conclusions, then there are conjectures because they have not seen anything. They say that the data is not available, but they're casting a doubt. Also, you are saying that there were suggestions given by the UPJN and represented that this is assistant engineers, whatever has been done, Highcourt order. That is one aspect. So, what is the next aspect you are moving to?
My lord, this particular opinion, lordship, what I am saying is, if this opinion has been misread or read in extension to what has not been written in the impugned order. If your lordship may just quickly point out that particular portion. On page number 57 of the impugned order, the paragraph 11, what the impugned order says is कि दोनों विशेषज्ञों के मुख्य निष्कर्ष निम्नवत हैं.
वो एक aspect हो गया ना. What I'm trying to suggest is formulate your points and address one by one. This is the point. These are the reasonings that you are offering the documents. Otherwise, it is becoming difficult to then deal with your submissions. What are they going to reply to?
So, lordship, may just have point number E of my submission.
A is process of recruitment.
E.
No, A you are not addressing first.
I will be addressing A since your lordship has referred to.
No, you are not. Don't go by what the code is saying. You have.
Yes, but since I have already.
You have numbered them as alphabetically, so therefore we are asking. Now E, it is E that you are addressing.
Yes, E was being addressed since it was.
Opinion of IIT and triple IT are contextual and inconclusive. All right.
The points are opinions of IIT and triple IT Allahabad were opinions given on the basis of data provided without any opportunity to candidates or applicants.
एक aspect है. Conclusions
Second,
recorded
the
are not
conclusions
definitive.
recorded in the report are not definitive, and the impugned order reads more into it. Third, the IIT Kanpur report is apparently not with respect to the junior engineers, as such specific findings cannot be read against the petitioner's hearing. Context on which the opinions are sought itself is a ground for rejection of the opinion, because this was not a fair opinion which was being sought.
And the refused to as report to not consider. Okay. This is complete.
Yes, the opinions have deliberately been reviewed to as report, though no cross.
Referred on actually refused.
No.
Referred to as report, though no cross-check was done by the professors. They have not reported their own.
Appreciate the value of which has been attached by UPJN with regard to these two reports. If your lordship may just recall the order.
But please go point by point. So
Yes.
E is complete.
No, I am making further submissions on E.
E.
Yes. My lord may kindly appreciate on point number E, the impugned order has been passed relying on these two reports only. SIT only two conclusions have been noted down, nothing further. The entire report, at least the selective reading of the report, has been reproduced in the impugned order, and thereafter the order.
What they do with the report may become a separate point.
Yes.
You are attacking the report and saying that this is contextual and inconclusive.
Right. And therefore,
that part of the submission is over.
Therefore,
how they treat it is another aspect.
Yes. Lordship may have point number 8.
Huh? Coming to A now.
I'll just go according to the submission.
Whichever way you want,
Yes.
that is your choice.
Understood.
Process of recruitment was in
In
accordance.
accordance with the advertisement. I got the advertisement, what you will find on page number 64
Of your rate.
of the advertisement. This advertisement at no place says that after the computer-based test, there would be any uploading of the answer sheet and objections to be filed by the candidate. The relevant part is on page number 67. Towards the bottom, परीक्षा 8th नंबर के नीचे चयन के लिए कुल 100 अंक होंगे। परीक्षा 2 चरणों में नियमानुसार होगी। प्रथम चरण कंप्यूटर आधारित टेस्ट वस्तुनिष्ठ प्रकार के 80 अंकों की होगी। परीक्षा का विषय अधिकतम 100। कंप्यूटर आधारित टेस्ट अंकों के आधार पर मेरिट सूची तैयार की जाएगी, जिससे साक्षात्कार हेतु अभ्यर्थियों को यथा आवश्यकता बुलाया जाएगा। And thereafter there is a sakshatkar. So there is no process provided in the advertisement that any uploading of the answer key was to be done and objections were to be got. This is the document by which you are communicating with the candidate. How will the candidate know that any objections are to be posted if you are not providing it over here? आपने work contract में क्या किया है arrangement with APTEC? That is not a privy. We are not privy to that contract as a candidate. And therefore,
it is not an issue between the candidate and the UPJN. The question has been thrown open by the Supreme Court to see if there was widespread illegality.
On that I will come.
Right.
But
so you are saying, therefore, confine your submission. Your submission is that there is no law requiring a particular procedure to be followed in such examinations. Now, once a procedure has been advertised and followed, there is no illegality per se. Alright.
Because that is the point.
Is there any decided law they are then going to rely on? That is there. That no, in such examinations, a challenge procedure must be offered, otherwise the procedure prescribed is invalid. Is there any law to that effect?
No.
I have neither appeared in such examinations nor I have done the work, so you will have to educate me on that.
My lord, I will.
ऐसा तो हमारी समझ से है नहीं.
But otherwise it cannot be because there are several examinations I have mentioned in paragraph 40 of.
And nobody has challenged it like that. Has anybody challenged it?
No, other than the UPJN, no one can challenge it.
No. Has anybody challenged the procedure as opaque? Any candidate?
Advertisement? No.
Advertisement condition, nobody has challenged.
No one has challenged. They have challenged that certain answers were incorrect and all. But they have not challenged the advertisement and the terms of the advertisement.
Terms नहीं challenge.
Not to our information. Point number.
So terms of advertisement not under challenge.
Right.
Only answers to कितने क्वेश्चंस को चैलेंज?
3 questions were challenged.
जूनियर इंजीनियर में एक भी नहीं हुआ है. पिटीशन कोई आई है?
जूनियर इंजीनियर में ही वो 1 4 टाइम्स हुई.
हाँ.
Of 2017 इसमें 3 questions हैं.
Answers to 3 questions out of 800.
आप उसमें तो 80 को कहेंगे कि PD appeared in one particular examination. So 3 out of 80 of his.
One shift.
Yes, but otherwise what the report says is 18 out of 400 are incorrect.
18 out of 400. But then 18 out of 400, nobody sought a relief. Relief in these matters is to be granted to that in the context of relief sought. So if there are 18 wrong but only 2 are challenged, only 2 will be considered. 16 तो आएगा नहीं. तो ये आपका पहला पार्ट सबमिशन का है. Then
इसमें part 2 है publication of answer key after computer based test not a universal.
ये तो इसी से कवर्ड हो गया. ये नहीं प्रोसीजर आपका नहीं प्रिस्क्राइब है.
इसमें मैं एक RTI दिखा रहा हूं पेज नंबर 98
भाई RTI क्यों दिखाइएगा? पहले आप लॉ बताइए ना क्या है. Is it the law that the examining body must publish a model answer key?
No, that is our submission, and in fact even in the advertisement it doesn't provide.
So therefore RTI क्या कर देगा?
RTI was,
unless somebody has set up that challenge, how does it become open in these proceedings.
The UPJN is now setting a challenge that since the answer key was not uploaded, so the process is initiated. In the impugned order,
Therefore, you are referring to RTA.
Therefore, I am referring to it.
बताइए कहाँ है?
Page number 98 में.
Yes.
वर्ष 2013 एवं 15 में जूनियर ये बिंदु संख्या 102 का रिप्लाई. वर्ष 2013 एवं 15 में जूनियर इंजीनियर की सीधी भर्ती के पद पर नियुक्ति हेतु सीबीटी परीक्षा के 50 कार्यालय अभिलेखों में रिस्पांस शीट अथवा आंसर शीट वेबसाइट पर प्रकाशित किए जाने की कोई सूचना उपलब्ध नहीं है. It was not even uploaded subsequently.
So UPJN has never followed it.
Yes. UPJN has consistently followed that they are not uploading the answer. Even in this examination, they are not uploaded. It was only after the change of things in Lucknow that these things cropped up and subsequently they uploaded the answer. I have made mention with regard to the examinations to which, my lord, no uploading is done till the exams are finally completed.
So this is your case that this is nothing new that has been done, so it cannot raise eyebrows. That can be a ground to suspect.
And therefore, a comparison to exam process followed.
That is another process.
IIT and otherwise is simply different and cannot be applied over here. My lord, so far as the wrong answers are concerned, it will not vitiate the selection process.
What is the law on that?
I refer the law. In paragraph number. It is Ran Vijay Singh versus State of UP 2018 to SCC 357.
Ran Vijay
Singh
versus
State of UP 2018 to Supreme Court cases 357.
2018.
Volume 2 Supreme Court cases.
Yes.
357.
Oh, yes.
My lord, thereafter, the answer key has not been held to be incorrect by the court of law till date. What in the impugned order they have referred that they have sent this answer key to 7 institutes, out of which 2 institutes have responded. One is MNIT, which probably.
That will conflict with Ran Vijay Singh and other law. The
Yes.
expert has to be of the examining body. They can't consult.
But kindly appreciate that this is the basis on which they are saying that you are tainted.
So you attain that, you address that. Now, why do you get sucked into their reasoning? They have gone. Your first submission is that they have gone on a tangent. Then you proceed to draw another tangent and leave the court in the middle.
My lord, if your lordship may just have the relevant part of the report which was filed in which they say that the answer key is incorrect, that is on page 121.
See, the legality of the issue has to be seen, not the politicality of political issue that may exist or may not exist. We are not concerned with that.
Why I am referring to this tangential argument also is that since the impugned order also.
Rest assured, your adversaries are drawing all tangents. They are coming. They will come down next week.
My lord, the impugned order actually refers to these points.
ठीक है, but try to bring it on the tracks on which in the context of a judicial review. So you are saying that there is no hard and fast rule how an exam is to be conducted. What that we have understood. Then you are saying that experts, so far as questions are concerned, that does not vitiate the entire examination procedure, because you have been following that for the last UPJN has been following it for many years, and in any case there is no cogent material to reach the conclusion hurriedly that the answer responses were wrong, because UPJN has itself not come up and taken a stand. It is only experts who have been consulted and they say, or it is the UPJN who says.
My lord, it is the UPJN which has filed the affidavit and therefore I was showing it.
दिखाइए कहाँ है?
That is on page number 121. This is part of the affidavit.
121 of the writ.
Of the writ petition.
क्या है
ये
किसका है?
टेबल फाइल किया था, ऊपर लिखा हुआ उत्तर प्रदेश जल निगम का वर्ष 2016
भाई यहाँ पे एक्सपर्ट कौन होगा मिस्टर मिश्रा?
इसमें 3 लोग लिखे हुए ऑलरेडी।
लॉ जो है उसके कॉन्टेक्स्ट में हु इज द एक्सपर्ट टू बी
But
रेफर्ड?
then the assumption cannot be drawn against me if the report is conflicting. That is what I am trying to show. I am not trying to prove which is the correct answer.
No. Who conducted the exam? Who will be the expert?
But this UPJN is not following.
That is what you say, that they have consulted somebody else.
Yes.
That's what Ranvijay Singh would say, or the other judgment should say.
That is precisely what I am showing to the lawsuit.
एपटेक द्वारा दिया गया, अभ्यर्थियों द्वारा दिया गया, एनआईटी द्वारा दिया गया, केएनआईटी द्वारा दिया गया, एपटेक ट्रस्ट दिया गया,
द्वारा दिया गया संशोधित। Now kindly see question number item।
तो एपटेक ने दिया ना
दोबारा आंसर नंबर 2 आप देखें।
हाँ,
अभ्यर्थियों एपटेक का जवाब था 7.5, अभ्यर्थियों ने जो भी दिया। एमएनआईटी का जवाब था 7.5, केएनआईटी का 7.5।
नाम वो नहीं देखेंगे, एपटेक ने खुद रिवाइज किया ना।
एपटेक on what basis?
We don't know, but that is the expert.
My lord, if your lordship may just have the impugned order once more, I will just refer very quickly. What they are saying is कि एमएनआईटी और केएनआईटी ने दूसरे ओपिनियन दिए कि हम एपटेक की बात नहीं मानते। That is the whole issue. उनका ये कहना है impugned order में कि एमएनआईटी और केएनआईटी ने दूसरे जवाब दिए कि हम ये बात नहीं मान रहे, and the assumption that 18 questions are wrong is on the basis of the report of MNIT and KNIT. Obviously, that is a wrong premise, and as your lordship is rightly saying, that it will be ultimately the final report of APTEC itself, but that they are not accepting. They are saying, no, MNIT said this, but that is what I am trying to show to your lordship. Even in the reports of MNIT and KNIT, there were discrepancies. They didn't give a uniform, say, no, this is east and this is west. And therefore, it cannot be even conclusively said that 18 out of 400 questions were incorrect. But that is the issue which will be decided subsequently. You cannot say that the candidates are tainted because of this particular position. बस एक और क्वेश्चन में दिखा दूं फिर I will just leave from this point.
So you are saying even that is though no definite opinion exists amongst the two consultants.
122 first में आप देखें क्वेश्चन जो भी है, earlier APTEC's response was not KNIT. MNIT said ring all, KNIT said not, APTEC said ring all. So this is a difference of opinion.
नहीं
APTEC ने initial कहा not,
एपटेक ने कहा नॉट और बाद में फिर एपटेक ने तो नॉट ही कहा।
हाँ, लेकिन जो एक्सपर्ट जिनको ये रिलाई कर रहा है उन्होंने डिफरेंट ओपिनियन दिया, नॉट एंड ring all. They didn't give a uniform opinion. That is what I am trying to show. And it goes on this list. So it cannot be even assumed that those 18 questions were incorrect. जिसके बेसिस पे ये कह रहे हैं कि 656 कैंडिडेट्स को इंटरव्यू में अलग से बुलाया गया। What they are trying to set up a case is कि अगर ऐसा होता तो वो 656 deserving candidates could have come for interview instead of the 656 undeserving. But where is the conclusive finding with regard to that?
नहीं तो 4 में देखिए तो रेट ऑफ फ्लो कैंडिडेट्स ने दिया, वेलोसिटी, मगर बाकी केएनआईटी ने भी सबने रेट ऑफ फ्लो ही दिया, एपटेक ने भी वही दिया।
वो पहले भी एपटेक ने रेट ऑफ फ्लो ही दिया, तो दिस इज नॉट अ रॉन्ग आंसर। माय सबमिशन इज दिस। ये
तो इसलिए उस पर कोई कंक्लूजन नहीं आ सकता।
जी 5 में देखिए नो कमेंट्स लिखा है एमएनआईटी का, केएनआईटी का एस्ट्रोनॉमर। Then 7 number पे ratio, there is a ratio question.
So mixed है, mixed है।
So therefore it cannot be said to be conclusive. The 18 questions are wrong, even for that matter. Well, then the second viewpoint is that the services have been dispensed after 3 years, more than 3 years of service.
That how can you succeed after direction issued under the Article 32? Once the Supreme Court says it's all laid open, examine. If it goes, it goes. ठीक है, आप retirement गए से पहले
this aspect has not been examined. What the Supreme Court decided
this was open for you to say there.
Then they left everything open otherwise. If I may point out that again, what they said is, other than the issues which we have decided, Everything is open.
Open, but doesn't mean
So
that
it doesn't mean-
anything open doesn't mean that you can to nullify. The High Court will say one constitutional court says nullify the order of the other constitutional court.
No, I'm not saying to nullify. We are limited to the extent it has been decided. But all other things are open.
Right. So it was open to you or not to say, plead before the Supreme Court that see now 3 years have passed. You may only issue a limited direction to
Junior
them.
engineers were not before the Honorable Supreme Court. It was the assistant engineers who went.
But it has been made applicable or to them or not.
They have said that you decide the issue entirely. But they also give a cautious word.
Joined on 16/1, worked till 22/3/20 without any interference. Thus cannot be removed following process of the All right. Any decided law on this? You will give that later.
Probation period under the service rule is of 2 years.
So you are all confirmed employees.
There was no confirmation order separate, but the probation period is 2 years, and there was no extension of probation. We have made it in the petition and so far as the junior engineers. The only service which was interfered was the services of the assistant engineer in the year 2000. Then, Your Lordship, the third point was the judgment passed by the Honorable Court in the special appeal was approved by the Honorable Supreme Court. It will not get washed away, my Lord. My respectful submission is this one submission. First leg of this argument is that the judgment of the Honorable Court decided certain issues. One of the issues was whether you took permission or not. One of the issues was whether the questions were wrong or not uploaded. These issues were subsequently approved by the Supreme Court. At the first stage, they didn't challenge. Subsequently, when they went after the review to challenge it, then the Supreme Court said, no, it is not open for you to challenge because it has already attained finality. You can only challenge to the extent of the liberty given. Liberty was given with regard to the inquiry. So, paragraph 14, with respect to commissioners, that the judgment of the Honorable Supreme Court dated 15/11/2018, which was passed in civil appeal number 11017 of 2018. Paragraph 14, Your Lordship has on the other day pointed out. That has to be read harmoniously.
Paragraph
14
of the order 32.
No, of the earlier order in civil appeal.
That is at page.
My Lord, it starts from page 193 and the relevant part is on page 215.
So rate
Of the writ petition.
नहीं इसमें तो नहीं पेज
214 में था.
हाँ
Paragraph 13 and thereafter 14. Suffice it to observe that by disposing the special leave petition filed by the appellant on the earlier occasion by the order dated 16 March 2018, this court has neither disturbed the conclusion reached by the High Court in its order dated 28 November 2017, nor granted liberty to the appellant to challenge the said conclusion in the review application, or for that matter, by way of fresh special leave petition. The relevant conclusion of the High Court in its order dated 28 November 2017 reads thus: in view of the above, we are of the considered opinion that the ensuing order dated 11/2017 has been passed in violation of principles of natural justice without issuing notice and without affording opportunity of hearing to the petitioners no exercise of the undertaking to distinguish the case of candidate and non-candidate candidate to arrive at the conclusion by passing the ensuing order. As such, the ensuing order dated 11/2017 is not sustainable and liable to be satisfied. So, my Lord, I submit before your Lordship that it has to be read, 13 and 14 has to be read together. What 14 says, the limited plea taken before this court as noted in first paragraph of order dated 16 March 2018 was to allow the appellant to rework the questions and answer sheet and revise the merits and issue fresh reasoned order after providing opportunity of hearing to the affected candidate. That option has been kept open. It is for the appellant to pursue the same. In other words, the appellant must in the first place act upon the order dated so and so, that was for his statement, has been quashed and set aside. The appellant may then proceed in the matter in accordance with law by passing fresh reasoned order. Indeed, by doing so, the appellant may take into consideration the previous inquiry reports and also the other relevant material documents which have become available to them. So now, what the liberty has been granted is the inquiry report. Inquiry reports with regard to any illegality being committed. The procedural aspect which has been followed by Jallikam is concluded by the division bench. That was found. Otherwise, what is the use of paragraph 13, wherein the Honorable Court holds that This court has neither disturbed the conclusion reached by the High Court in its order.
Once, all right. So, what will be the effect of the subsequent order passed by the Supreme Court?
The subsequent order is only with regard to the order dated 2 March 2020, which is impugned before your lordship. It cannot reopen a conclusion which has already been drawn. Even the order passed under Article 32 does not wash away the earlier orders of the Supreme Court. In fact, it only clarifies the earlier order. What has happened that in the earlier order of this particular order, the Honorable Court said you decided after given opportunity as court that is not applicable. Because the Honorable Court said you segregate the candidate. Thereafter, what the Judgment did was they said there is no possibility of segregation, and therefore no opportunity needs to be given in view of both Chakradhar and the observations made in this. The Supreme Court said yes, they are right if no segregation is possible, but that part is to be decided by the High Court whether segregation is possible or not. So what has been limited by the Honorable Supreme Court in Article 32 is only limited to the extent of natural justice, and that too if the conclusion is confirmed that there is no segregation possible. If the segregation is possible, then natural justice will come into play, playing on both Chakradhar and other judgments which have been reported by the Honorable Supreme Court, and even by them in the Hindu law.
All right. On this aspect, anything more?
My lord, so this was one thing that the judgment is still applicable and holds good with regard to the issues which have already been adjudicated.
So A, B, and C and E are covered.
My lord, see, there is a second alternate argument also that even if it is held that the
All right, continue that tomorrow then. कितने fresh हैं कल?
My lord है 90.
हैं?
90.
19. तो कम है थोड़े सा.
Grade 6 उसमें 5 ही है.
And top 10 कितने हैं?
Top 10 में my lord है 8 cases. 8 cases है.
8 है.
8 है. उसके अलावा my lord कई tied up matter लगे हुए हैं. लग रहा है जैसे पिछली बार आया था संजय सिंह वाला उसी तरीके
वो तो कोई दिक्कत नहीं.
20-22 केस लगे दिखा रहा है इसमें.
पता करा लीजिए क्या
हम पता ठीक पता एक मेंशन किया था रेस्टोरेशन.
Bill number 144, restoration matter, Mr. Suresh and the
Sorry?
Steps न लेने की वजह से.
All right. Learned counsel for the petitioner applicant submits. Why did you take time? आपने देखी है ऑर्डर शीट? You can't every time आप लोग बड़े आराम से जो चीज आपको लगे परसीव करते हैं आपकी गलत ऑर्डर हो गया, you will just make a statement. You don't even bother to check the order sheet. नहीं देखी ऑर्डर शीट? Matter was listed before in the chamber of registrar. Shri Suresh Chandra Dwivedi, learned counsel for the petitioner, prays for and is granted time till 20th of July 22 for taking steps in compliance of High Court's order 17/5/22. इसलिए लगाए चैप्टर 12 में आप wrongly लगाए तो वो अलग बात है. आप कह रहे हैं कि ऑलरेडी अपियर कर रहे हैं. Who is appearing for the 8 and 9? When did you file appearance? कहाँ लिखा है आपने एप्लीकेशन में that they had filed appearance before the order came to be passed?